They walked into the courtroom as if the weight of centuries pressed down on them. Not just the walls of London's High Court, not just the heavy mahogany benches, the towering ceilings, or the hush that fell over anyone who dared speak too loudly. No, the weight was something more personal, more immediate, the unrelenting gaze of history, expectation, and scandal. Prince Harry, Duke of Sussex, appeared, though not with the regal ease many might imagine when picturing royalty in a courtroom. There was tension in the way his shoulders hunched, the way his hands fidgeted slightly under the folds of his tailored suit. And in that moment, everyone watching, reporters scribbling furiously, photographers capturing every blink, every twitch, felt a subtle but unmistakable sense that something was about to crack. But what? And why now? Before we continue, please hit the like button, subscribe to the channel, and turn on the notification bell for updates. Because this wasn't just another media spat, another headline to scroll past in the quiet desperation of one's morning feed. This was Harry in a rare, almost intimate confrontation with the machinery of the press he has spent years railing against. He wasn't on a stage, under lights designed to flatter or highlight charm. He was in a place designed for truth, or at least for the law's version of it. And in front of him, waiting patiently, were lawyers armed with the meticulous patience of the English legal system, ready to dissect every word, every expression, every hesitation. Yet before we even get to the details of Harry's accusations against the publisher of the Daily Mail, there is a tension that runs deeper than the case itself. Princess Anne, known for her disciplined demeanor, her reputation as the family's voice of reason, the unflinching standards she holds herself and others to. Behind closed doors, sources suggest, and has issued warnings, stern, quietly furious warnings, about conduct, decorum, and perhaps even the trajectory of Harry's choices. It's a reminder, one that few outside the inner sanctums of royalty fully understand, that even in modern times, the monarchy operates with a set of invisible but powerful expectations. And when those boundaries are tested, the consequences ripple far beyond the family itself. And there is Catherine, Duchess of Cambridge, present in the narrative not as a witness, but as a specter of tension. A figure whose mere presence, whose interactions with Harry in prior public and private moments, are said to have sparked conflicts so subtle, yet so corrosive that insiders describe them as quiet storms. How does one measure the impact of emotional friction in a family that is constantly scrutinized by millions? Can a slight misstep in words or gestures in one hallway reverberate into headlines across the globe? In this case, it seems the answer is yes. Meanwhile, Meghan Markle, the Duchess of Sussex, is cast not as a participant in this courtroom drama, but as a shaping force behind it. Those close to Harry suggest that years of tension, disagreements, and what some call relentless personal strain have left marks on him. On his temperament, his decision-making, and perhaps even his judgment in the proceedings at hand. To frame it differently, the courtroom might be seen as the culmination of years of private struggles made public, not just with the press, not just with family, but with oneself. The legal case itself is complex, layered, and far from a simple narrative of right versus wrong. Harry accuses the publisher of the Daily Mail of unlawful information gathering, a term loaded with implications, history, and nuance. The allegation is that the newspaper, or those acting on its behalf, sought or obtained private details about Harry and Meghan's lives, details that were then published in articles designed to intrigue, scandalize, or simply sell copies. It is not merely a question of intrusion, but of intent and legality. Was this an overzealous pursuit of stories, the kind of reporting that skirts the edges of ethics? Or does it cross a line, entering into illegal activity, surveillance, and covert operations? The Daily Mail's response is predictably firm, almost rehearsed, that the accusations are preposterous and without foundation, that their stories are based on legitimate sources and responsible journalism. And yet, there is a subtle irony here. Many of the stories in question were published 20 or more years ago, at a time when neither Harry nor Meghan had filed complaints. The question lingers, why now? Why escalate a decades-old concern into a high-profile courtroom confrontation? Is it the weight of accumulated grievances? Or is it strategic timing, taking advantage of public attention, legal precedent, or shifts within the royal family itself. Observers watching the trial unfold in real time note Harry's intensity. Some describe moments where he appears almost on edge, a flicker of frustration crossing his features when confronted with line-by-line challenges to his claims. Others note a more calculated poise, the ability to anticipate questions and to frame responses in a way that maintains dignity while signaling grievance. It's a tightrope performance, and one that exposes the delicate interplay between personal emotion and public perception. How does a royal navigate anger, betrayal, and legal strategy all at once? And what does this reveal about the man behind the headlines? Adding another layer to the narrative is the schedule of the trial itself. Designed to stretch over 2 months and conclude on March 26th, the proceedings are meticulously planned, with both legal teams agreeing on timetables, evidence presentation, and procedural matters. For those outside the courtroom, it might appear slow, even ponderous. But in reality, each session carries significance, each testimony builds upon the last, and each pause allows for reflection, media analysis, and the inevitable speculation that drives public fascination. The courtroom, in this sense, becomes both stage and laboratory, a place where fact, emotion, and interpretation intermingle in real time. The judge, Matthew Nicklin, remains a figure of quiet authority. His role is to navigate the legal complexities, weigh evidence, and ultimately deliver a ruling that will either validate or dismiss Harry's claims. But even the most impartial observer cannot ignore the human dimension here. Decisions made in the courtroom do not exist in a vacuum. They will ripple through royal protocol, media coverage, and public opinion, influencing perceptions not just of the case, but of Harry, Meghan, and the monarchy at large. And as we watch, as the days unfold, the question becomes unavoidable. What is Harry really seeking? Justice? Vindication? A measure of control over a narrative that has long felt dictated by others? Or is there something more deeply personal at play, a confrontation not just with a publisher, but with the very architecture of expectation, scrutiny, and legacy into which he was born? Each answer raises further questions. Each revelation opens new avenues of curiosity. Meanwhile, whispers of internal dynamics continue to surface. Princess Anne's interventions, the subtle tensions with Catherine, the long-term effects of Meghan's influence. They are all pieces of a puzzle that extends far beyond legal statutes or media ethics. These are human stories, stories of pride, pressure, resentment, and love entangled in a web that the public rarely sees in full. And yet, each small interaction, each stern look, each carefully worded statement feeds into a larger narrative that is now being publicly tested, dissected, and debated. But perhaps the most unsettling element is this. Even as the courtroom drama unfolds, as statements are read and objections made, there is a sense that the most critical moments may not be fully visible to anyone outside those walls. We see glimpses, flashes of expression, moments of hesitation, carefully crafted words, but we do not witness the full interior experience. Harry's mental state, the private calculus behind each response, the subtle influence of family relationships on his testimony, all of this remains largely inferred, interpreted through the prism of reporting and analysis. And that is the tension at the heart of this story. It is at once legal, emotional, and deeply human. It is about a man confronting forces larger than himself, about a family navigating the pressures of tradition and public scrutiny, about a media ecosystem that thrives on both revelation and controversy. Every statement, every reaction, every pause carries weight, because the audience is not just watching a trial, they are watching the evolution of a narrative that has been decades in the making. So, as the courtroom doors open and the cameras focus, the question for the world is simple, yet profoundly complex. How will this confrontation reshape Harry's public image, his family dynamics, and the broader conversation about privacy, accountability, and the press? And, more importantly, what hidden forces, old grievances, subtle warnings, strategic decisions, are at play that the public cannot see? The clock ticks, the gavel waits, and every word matters. Because what came next? What would unfold over the weeks of testimony, legal maneuvering, and personal revelation was about to change everything. and no one, not even those inside the courtroom, could predict the full consequences. This is where we begin, where the story starts to unfold not just in the dry text of legal filings, but in the charged atmosphere of human emotion, legacy, and stakes that are both deeply personal and globally resonant. But the courtroom is only the stage. The drama is far more intricate, far more human, and far more consequential than the headlines would suggest. And as the first witness is called, and the first statements echo through the chamber, the true story begins to reveal itself, layer by layer, contradiction by contradiction, tension by tension. And yet, even now, before the first evidence is fully examined, a shadow lingers. Warnings issued quietly by Princess and moments of tension with Catherine, the weight of Meghan's influence, and the burden of history itself. How will Harry navigate these? Will the courtroom provide clarity, or will it only deepen the intrigue? But what came next would change everything, and no one saw it coming. The courtroom was quiet, almost too quiet, in those moments before testimony began. You could hear the shuffle of papers, the soft scrape of a chair, the distant hum of a camera motorized on a tripod. But beneath that stillness, there was tension so palpable it almost had a physical weight. It pressed in on everyone, journalists, onlookers, legal staff, and most of all, on Harry himself. He sat, hands folded, eyes shifting subtly toward the entrance where his lawyers would soon walk in with prepared statements, notes, and the weight of strategy. Was he thinking about the case, or was he reliving years of intrusion, of feeling exposed, of private moments dissected publicly without consent? That distinction, small yet profound, would shape how he spoke, how he reacted, and how the court would perceive him. There was a moment, fleeting but telling, when Harry's gaze flicked across the room toward the press benches. Reporters leaned forward, notebooks open, pens ready. Photographers poised their cameras, lenses trained on subtle twitches, the nearly imperceptible shift of eyebrows. And in that instant, it was clear, Harry was both aware of the audience and resistant to it. A contradiction in motion. He had spent years criticizing media intrusion, yet here he was, in a venue that amplified every word, every pause, every gesture. What did it feel like to speak your grievances in the very arena where the very offenses occurred? How does one measure courage when the stakes are personal, historical, and intensely public all at once? Then there was the matter of timing. Why now? Why take stories that some were 20 years old, stories that had passed without complaint, and escalate them into a high-profile legal confrontation? Analysts outside the courtroom whispered theories. That Harry's legal team had found new evidence, that public sentiment had shifted in a way that favored him, or that this was a calculated move to assert agency over his own narrative. Perhaps it was all of the above. Perhaps it was something deeper, more private, a culmination of long-standing grievances that had quietly fermented into a legal battle, ready to spill into full view. The question remained, how much of this was legal strategy and how much was personal vindication? The role of Princess and could not be overlooked. Sources describe her as a quiet force, someone who observes, calculates, and when necessary, intervenes with precision. Within the palace, she has long been seen as a moral compass, someone who balances duty with clarity of thought. And yet, in Harry's journey, Anne's influence seems to have both guided and constrained. Her warnings, though not public, are said to have been sharp, concise, and unyielding. She has, according to insiders, reminded Harry of expectations, not just about behavior, but about the potential fallout from actions that appear reckless or impulsive. How much did those admonitions weigh on him as he prepared to face the court? Did they fuel anxiety, or did they sharpen his focus? And for a man used to carrying the combined weight of public and private expectation, how do you process counsel that is stern but not indulgent, principled but unsentimental? Harry's relationship with Catherine added another layer of complexity. These were not legal confrontations between estranged acquaintances. There were shared histories, public appearances, mutual obligations. Yet, observers note that underlying tensions between Harry and Catherine have long existed, sometimes simmering quietly, other times spilling over in ways visible to insiders. How does one measure the subtleties of such friction? A word spoken in jest, a comment taken out of context, a glance interpreted as judgment. It all matters when the world is watching and every action is scrutinized. And in court, these relational dynamics are inevitably projected onto broader interpretations of temperament, of credibility, of motive. The courtroom, in essence, becomes a lens magnifying not just legal argument, but interpersonal dynamics amplified 100-fold. And then there was Megan. Always Megan, it seems. She was not physically present in the courtroom, but the influence attributed to her presence, past and ongoing, was undeniable. Sources close to Harry suggest that the years spent navigating conflicts, public scrutiny, and intense media pressure alongside her had left indelible marks. Some describe Harry as more guarded, more volatile in certain moments, more cautious in others. These are the kinds of details the court cannot measure, yet the human element is impossible to ignore. How does past strain shape present testimony? How much of one's emotional state is admissible in legal context, and how much leaks out anyway, into gestures, pauses, inflections, and the subtle rhythm of speech? As the trial progressed into its first day of testimony, the procedural rhythm began to settle in. Lawyers laid out schedules, introduced preliminary arguments, and positioned witnesses in ways calculated to maximize clarity, but also strategic impact. The slow build of tension was deliberate. Each session, each statement, each cross-examination crafted to create layers of narrative, gradually revealing the picture the legal team wished to paint. And yet, the longer the process continued, the more the courtroom itself seemed to transform. It was no longer simply a venue for law. It became a theater of human emotion, conflict, and strategy, a place where past grievances, present stressors, and future uncertainties intersected with chilling clarity. Media coverage, of course, was relentless. Each reporter, each outlet, offered its interpretation, some sympathetic to Harry's grievances, some skeptical of motives, some focused on the minutiae of legal argument. The paradox here is striking. The very press that Harry accuses of intrusion becomes a mirror reflecting his own actions and strategies, shaping public perception even as the court deliberates. How does one negotiate credibility when your narrative is being filtered, interpreted, and amplified in real time? And more crucially, how does a royal navigate agency when every statement risks distortion? Meanwhile, within the legal arguments, there were subtle indications that not everything would be straightforward. The Daily Mail's defense, firm, concise, and unwavering, emphasized responsible journalism, reliance on legitimate sources, and the absence of any complaint at the time of publication. Yet, for observers, the tension lay not in whether these claims were legally sound, but in how the court would perceive the human and emotional dimension of Harry's experience. Can law fully encapsulate the sting of betrayal, the invasion of privacy, the erosion of trust? Or does it only scratch at the edges, leaving the human story partially obscured, partially unresolved? And then there was the rhythm of anticipation itself. The trial, set to run for more than 2 months, created a temporal pressure, a slow burn that forced everyone involved, participants, media, and public alike, to live within a framework of expectation, speculation, and uncertainty. Each day of testimony became a narrative unit, each objection and response adding texture to a story that was far larger than the sum of legal documents. In that sense, the trial operated not just as a legal proceeding, but as a live, unfolding narrative, a serialized drama unfolding in real time, with millions of spectators, countless interpretations, and stakes that extended far beyond the courtroom walls. The judge, Matthew Nicklin, maintained a quiet authority, rarely revealing personal inclination, but the weight of his role was felt nonetheless. Every ruling, every procedural decision, would carry implications, some subtle, some profound, for how the story was told, how evidence was framed, and how Harry's arguments were received. The tension was not simply between parties. It was structural, procedural, and human, a mesh of legal rigor and emotional undercurrent that made every moment fraught with anticipation. And yet, even as all of this unfolded, a crucial factor lingered beneath the surface: Harry himself. What drove him into this confrontation, at this moment, with such intensity? Was it the pursuit of justice? The desire for vindication? Or the need to reclaim narrative control in a life long scrutinized by others? Perhaps it was all of these. Perhaps it was more subtle, more human, a confrontation with unresolved frustration, familial tension, and a sense that privacy, dignity, and personal boundaries deserved defense, even at immense personal cost. The day's proceedings closed, but the weight of the encounter lingered. Reporters filed their notes, editors drafted headlines, social media buzzed with speculation. And yet, the most consequential moments had not been fully captured. The personal stakes, the judgments, the subtle expressions, the half-spoken thoughts that never left the courtroom walls, remained veiled, leaving the world to wonder, interpret, and anticipate. And in that anticipation lies the essence of the story. For this is not just a tale of litigation. It is a human story, a royal story, and a media story intertwined in ways that challenge easy understanding. It is about expectation, about scrutiny, about the consequences of living life under a microscope, and about the rare, almost unbearable tension of seeking justice in a system that balances legality with human complexity. What happens when the very forces that have shaped a life, family expectations, media pressure, historical scrutiny, converge in a single, controlled environment like a courtroom? How does a man navigate anger, betrayal, love, and duty all at once? And as testimony deepens, as contradictions emerge and stakes escalate, the answers may surprise even those who have followed this saga most closely. But what came next would shift the tension from legal argument to deeply personal revelation, and it was something no one outside the courtroom could have anticipated. What does it feel like to be both accused and accuser in the same room? That question hung over the courtroom as Harry took the stand for the first time. Not just a witness, not just a claimant. He was a figure caught between history and immediacy, between personal grievance and public spectacle. As he adjusted his notes, shuffled his papers, and tried to steady his breathing, there was a tension that could almost be measured in the air. Some would call it anxiety. Others, barely suppressed frustration. The cameras rolled. The pen scribbled. And Harry's gaze, sweeping briefly across the gallery, carried both resolve and something unspoken, something that hinted at the private burden he had been carrying for years. The first question came, soft, procedural, almost innocuous on its surface. Yet beneath the words lay the trap of nuance. Can you explain how you first became aware of the alleged unlawful information gathering? The barrister asked. A simple opening, but it was a doorway into decades of frustration, scrutiny, and privacy violations that Harry had endured. And as he began, carefully, measuredly, the courtroom seemed to lean in. This wasn't just testimony. This was revelation. Each sentence was loaded, not just with legal significance, but with the weight of lived experience. Harry described moments that were almost mundane in isolation. A phone left unattended, a journalist lurking too long, a story published with intimate detail that made him pause, wonder, and ultimately, feel violated. But together, these moments created a pattern, a timeline of intrusion that spoke louder than any single incident could. And the tension grew. Because even as he recounted these events with deliberate composure, the subtext was clear. These were personal boundaries violated, trust broken, and consequences suffered, not abstract, but deeply human. Throughout, there was the ever-present shadow of family dynamics. Princess Anne's influence, though invisible, seemed to hover. Those who had observed the family suggest that Anne's quiet warnings, her insistence on prudence, may have prepared Harry for this, or perhaps weighed heavily on him, reminding him that while justice was his aim, conduct mattered. He was not just a man testifying in court. He was a royal under scrutiny, a public figure whose every movement, every intonation, would be examined for both intent and propriety. How does one navigate that kind of duality? Can a royal remain authentic under relentless observation, or is every gesture inevitably politicized? Then there was Catherine. Although absent from the proceedings, she occupied the space nonetheless. Sources note that prior interactions, both public and private, had created subtle fissures in the family dynamic. Small slights, perceived or real, created an undercurrent of tension that was now being refracted through the courtroom lens. As Harry recounted incidents from years past, there was a subtle irony. He was defending privacy while indirectly exposing the emotional strains within the family. The court, the press, the public, everyone was watching him navigate personal, familial, and legal minefields simultaneously. Meghan's influence was similarly felt, though not tangible. Friends and insiders described the effect she had on him over the years as transformative, at times supportive, at times a source of friction. Now, in the courtroom, the residual impact was visible in posture, tone, and response. He was cautious but forceful, deliberate but emotionally raw in moments where restraint almost faltered. Could the court fully understand the interplay of personal relationships on testimony? Perhaps not. Yet the nuances were apparent to those trained to observe human behavior, subtle but undeniable. The way he hesitated before mentioning certain publications, the careful phrasing when referencing past media coverage, the almost imperceptible shift in demeanor when the discussion veered toward family-related stories. The lawyers for the Daily Mail, calm and unyielding, presented counterpoints with the precision of chess masters. Each question, each objection, was calculated to probe the credibility of Harry's claims while maintaining a posture of impartial legality. They emphasized the responsible nature of journalism, the use of legitimate sources, and the absence of complaints at the time of publication. But what legal arguments could ever fully address the human sensation of violation? The courtroom was structured, regulated, methodical, but human emotion does not always conform to rules, procedures, or precedent. And in this tension, the drama of the trial escalated. Journalists present in the courtroom could barely contain the energy. There were whispers about every nuance, notes scribbled frantically, lenses adjusting to catch the subtlest gestures. A raised eyebrow, a slight sigh, a pause before responding, all became part of the story being written in real time. Outside, the media spun narratives, some sympathetic, others skeptical. Yet even the most detailed reports could only approximate the complexity of what was unfolding inside. There was a lived reality here, a collision of law, history, family, and human vulnerability that few outside the courtroom could fully grasp. Harry's testimony grew more pointed as the questioning deepened. Specific publications were dissected, events recounted with timelines and context. And yet, with each detail, an emotional subtext became clear. This was about more than legal remedy. It was about reclaiming a sense of personal agency, asserting boundaries, and confronting an institution, both familial and journalistic, that he felt had, for too long, dictated terms over his life and narrative. Can one ever truly measure the impact of public scrutiny on private well-being? In Harry's case, it was visible, palpable, undeniable in the way words were chosen, in the controlled intensity of delivery. And still, there was Princess and the unseen presence. Insiders suggest she had briefed counsel, offered guidance, reminded Harry of both opportunity and risk. Her reputation for decisiveness and clarity meant that her influence was felt not as overt direction, but as an internalized standard. Perhaps this was why Harry's testimony, though emotionally charged, remained disciplined in tone, careful, deliberate, precise, yet with cracks that revealed humanity. How do familial expectations shape legal performance? And to what extent can internalized counsel both protect and constrain? By mid-afternoon, tension had shifted subtly. The initial procedural calm gave way to deeper, more probing questions. Witnesses, affidavits, and prior publications were laid bare. The legal battle had moved beyond broad claims into detailed examination. And for Harry, each moment demanded balance. Assertiveness without aggression, clarity without overexposure, emotional honesty without vulnerability that could be exploited. Could anyone truly manage that balance under the glare of history, media, and familial expectation all at once? The answer was not yet clear, even to him. And then, in a moment that few outside the inner circle would understand, a question was posed that changed the tenor of the room. It was subtle, almost casual, but loaded. Did you ever feel personally targeted by these publications beyond the legal definition of intrusion? A simple phrase, yet it opened a door into deeply personal territory. Harry paused. The room held its collective breath. In that pause, Decades of personal strain, media scrutiny, and public expectation seemed to converge. This was no longer about law. This was about lived experience, human emotion, and the private battles that had remained largely unseen. How do you convey years of intrusion in a matter of words? How do you translate emotional violation into testimony that is admissible, understandable, and impactful? Harry's response would reveal not only his experience, but the delicate balancing act of presenting humanity within a legal framework. Every word mattered, every nuance counted, every pause became a statement in itself. And those watching closely could see that this was the turning point, the moment where legal proceedings and human reality intersected with unmistakable clarity. But even as the testimony deepened, the courtroom's atmosphere shifted again. A subtle tension emerged between assertion and restraint, between public perception and private feeling. The layers of influence, Anne's guidance, Catherine's indirect presence, Meghan's lasting impact, the media's relentless gaze, wove together to create a complex emotional landscape. And navigating that landscape required every ounce of composure, every strategic calculation, every instinct honed through years of living under scrutiny. What would come next would force Harry not only to defend his legal position, but to confront the deeply personal implications of past actions, past relationships, and past media exposure. And in doing so, the trial would move beyond precedent and argument into something far more revealing. The human cost of life lived under unrelenting observation, and the pressures that shape decisions in ways the public rarely sees. The tension didn't end when testimony adjourned for the day. For Harry, the courtroom was just one layer of stress stacked upon years of unresolved conflicts, scrutiny, and unrelenting expectation. Outside the chamber, the media swirled, dissecting his every word, every inflection, every hesitation. Headlines proclaimed bravery or instability, loyalty or recklessness, sometimes in the same paragraph. And somewhere in the midst of it, Harry had to carry the private weight of family judgment. Princess Anne's influence, though indirect, lingered like a shadow over every strategic choice he made. The counsel she offered, quiet, firm, principled, was never about soft encouragement. It was about control, conduct, and consequences. And for Harry, that was a double-edged sword. The advice was necessary, but the reminder of scrutiny felt relentless. Catherine's presence, or more accurately, her influence, was more complicated. Not present in the courtroom, yet her existence within the royal narrative imposed an invisible boundary. For years, tension between her and Harry had been described by insiders as subtle, the kind that didn't erupt publicly but left emotional fissures nonetheless. Small interactions, fleeting words, gestures captured by media or interpreted by aides, layered with expectation and misinterpretation. What does it mean to be constantly filtered through other people's perception? How does one defend oneself legally while managing complex relational dynamics that are, by design, invisible to the general public? And then there was Meghan. Even in her absence, her impact was tangible. Those close to Harry suggested that years of pressure, negotiation, and personal conflict within the marriage had left marks on temperament, decision-making, and the way he interacted with the courtroom process itself. Some observers remarked that the careful phrasing, the almost meticulous calibration of tone, seemed to reflect a life spent defending both public image and private truth. The courtroom, then, became more than a site of legal judgment. It became an arena where past personal struggles were being tested under the cold, bright light of scrutiny. But this was not solely about family or media. Harry's own psychology, forged under intense public attention, played a central role. A life lived under the microscope does strange things to perception, judgment, and emotional regulation. Anger can flare in unexpected ways. Vulnerability can feel like liability. Restraint can become performative. Observers noted moments when Harry's composure was nearly perfect, a masterful balancing act of legal precision and emotional self-control. And then, in quieter, more human moments, subtle shifts. An eye flicker, a slight tremor in voice, betrayed the weight of years spent navigating invasion, misrepresentation, and expectation. The press had a way of magnifying these subtleties. Each gesture was fodder for commentary. Each pause, each careful choice of word, was interpreted and dissected. Headlines transformed hesitation into weakness, caution into evasion. And while Harry's legal team worked to present evidence methodically, they were aware that public perception might not align with courtroom logic. The tension between legal strategy and narrative control was nearly unbearable. Could a man testify truthfully while the world simultaneously rewrote his reality in real time? Meanwhile, the Daily Mail's legal defense remained poised and methodical. Their statements emphasized legality, precedent, and journalistic legitimacy, but they also introduced subtle pressure. By framing the stories as based on legitimate sources and emphasizing the absence of prior complaints, they created a quiet, almost insidious narrative that Harry's grievances were delayed, possibly opportunistic, and certainly open to scrutiny. And even as the judge listened impartially, the courtroom itself absorbed this tension, layering legal argument over human emotion in ways that were often invisible yet deeply felt. What Harry had to navigate was not only law but expectation. There was the weight of his own history, his own personal standards, and the perception of millions outside the court. And within that, the added pressure of family oversight, a family whose reputation, internal dynamics, and silent rules influenced every step. Anne's indirect warnings were not threats. They were calibrations, subtle reminders that choices carry consequences far beyond the immediate moment. Even the physical space of the courtroom added to the psychological strain. High ceilings, the echo of footsteps, the ordered arrangement of desks and chairs. These elements reinforced hierarchy and authority. Every movement, every gesture, was amplified, consciously or not. And Harry, like anyone trained to inhabit public life, was acutely aware of the optics, aware that even a small misstep might be magnified into a public narrative he could not fully control. The irony was stark. He was suing over intrusion, yet in doing so, placed himself squarely under another kind of intense observation. Friends and aides describe a careful preparation process for this trial, one that involved more than evidence review. He rehearsed testimony, anticipated questions, and trained himself to regulate responses that could reveal vulnerability. But even preparation cannot fully mitigate the human response. The gut reaction, the internal memory of years of scrutiny, betrayal, and perceived injustice. That tension between preparation and lived experience played out in subtle ways. A pause before naming a publication, a carefully chosen phrase, the way a point was emphasized or deferred. This interplay of law and emotion, of public perception and private experience, is what makes the trial so compelling. For the first time, the public witnesses not just legal strategy, but the lived reality of intrusion and the human cost of relentless media attention. And yet, what we see is only a fraction of the total story. The unseen layers, late-night discussions with lawyers, whispered family counsel, the quiet processing of emotion, remain opaque, only hinted at through gestures and tone. Observers noted that Harry's testimony increasingly reflected these dynamics. What began as procedural statements evolved into a subtle negotiation of narrative control. He asserted rights, clarified perceptions, and delineated boundaries with precision. Each word was both a legal claim and an emotional statement. And while the Daily Mail's defense maintained calm objectivity, the tension was almost tactile, two worlds colliding, law and lived experience, right and perception, accusation and memory. Meanwhile, media narratives outside the courtroom shifted as days progressed. Some framed Harry as vindicated, others as reactive, still others as a man overwhelmed by decades of intrusion. The contradiction itself fueled speculation. How could the same testimony provoke both sympathy and skepticism? The answer, of course, lies in the complexity of human experience. Truth is rarely symmetrical, emotion is rarely linear, and perception is always filtered through the lens of personal bias. Within the family, speculation persisted. Anne's quiet oversight was interpreted by some as protective, by others as critical. Catherine's indirect role was debated endlessly in reports, with each gesture or statement interpreted as influence. And Meghan, though absent, remained a focal point of analysis. her presence invoked as a shaping force in both past tension and current proceedings. For Harry, this meant balancing legal focus with the reality of relational weight, a task that demanded extraordinary composure. The cumulative effect of these pressures became most visible during cross-examination. Questions shifted from broad legal principle to highly specific incidents. Harry's recollection, phrasing, and emotional responses were scrutinized in minute detail. It was a test not only of memory, but of emotional endurance. Could he maintain consistency under relentless questioning? Could he navigate contradictions, protect privacy, and preserve dignity simultaneously? And in those moments, every observer, legal, familial, and public, felt the stakes climbing higher. And yet, as the first week of testimony drew to a close, a subtle but significant shift occurred. The courtroom, previously structured and methodical, began to reveal cracks, not in the law, but in the human narrative. Personal grievances intertwined with legal claims. Private influence intertwined with public statement. And the weight of past media intrusion, long simmering beneath the surface, began to manifest in unexpected ways. Pauses, emotion-laden gestures, moments of tension that transcended procedural expectation. What no one could anticipate was the tipping point approaching. The moment when legal argument would collide with deeply personal revelation, where the courtroom would no longer simply be a venue for evidence, but a stage for confessions, contradictions, and emotional exposure. And that moment would forever change how the public perceived not just the trial, but Harry himself. What happens when a man spends decades being observed, recorded, and analyzed, only to find that his every attempt at control is met with renewed scrutiny? That question was alive in the courtroom as Harry continued his testimony. It was one thing to face lawyers, judges, and procedure. It was another entirely to confront the intangible yet omnipresent force of the media. The press, always waiting, always watching, always ready, was not just a backdrop, but a participant in this trial. Every word spoken in the courtroom would ripple outward, dissected, debated, and distilled into headlines that would shape perception long before any legal judgment was rendered. Harry, acutely aware of this, chose words with care. But careful phrasing could only go so far. There is an inherent tension when your narrative is filtered through layers of interpretation. Gestures become statements, pauses become omissions, and subtlety becomes contract. Duality, asserting truth while anticipating how every sentence would be reframed in public discourse. Inside the courtroom, the battle over narrative extended beyond words. Body language, tone, and inflection all mattered. Harry's posture, a mix of formality and quiet restraint, spoke volumes. Small adjustments, a folded hand, a subtle lean forward, the measured rate of speech, conveyed both confidence and underlying tension. Observers familiar with nonverbal cues could sense the strain. The weight of decades of exposure, the pressure of familial expectation, and the awareness that the courtroom's walls could not fully contain the forces converging upon him. Meanwhile, the media, outside the courtroom, operated as both audience and amplifier. Journalists filed stories at breakneck speed, emphasizing the most dramatic elements of testimony. Each outlet approached the story with a particular lens. Some highlighting Harry's courage, others questioning his motives, some dissecting minute gestures as evidence of composure or distress. Social media reacted in real time, amplifying partial narratives and interpretations. For Harry, this meant that the trial's impact was not confined to legal outcomes. It extended into the public consciousness, where perception could shape legacy and influence even before judgment was delivered. And yet, the media's role was not merely adversarial. For Harry, careful interaction with the press offered a form of strategic leverage. By controlling what was disclosed in testimony, by framing incidents with precise language, and by carefully calibrating emotional expression, he could influence narrative direction without stepping outside legal constraints. But the margin for error was thin. A misstep, a poorly chosen word, or an overlooked detail could be magnified into controversy. Every sentence became both shield and sword, a tool of defense and assertion in a complex, high-stakes environment. At the same time, the psychological weight of prolonged scrutiny became more apparent as the trial progressed. Friends and insiders noted the cumulative strain, hours of testimony, repeated cross-examination, the constant awareness of media framing, and the invisible pressures of family expectations. The effect was subtle but real. Moments of hesitation, glimpses of emotion beneath carefully controlled expressions, a heightened sensitivity to tone and reaction. It was as if the courtroom itself, with its formal structure and procedural calm, became a pressure chamber, compressing years of personal and public tension into every exchange. And yet, despite the intensity, Harry displayed remarkable resilience. Witnesses described him as focused, deliberate, and responsive, demonstrating a deep understanding of both legal strategy and personal narrative. He could answer questions with clarity, navigate contradictions without faltering, and maintain composure under relentless scrutiny. But within that composure, there remained an undercurrent of tension, a reminder that legal skill alone cannot shield one from the human consequences of long-term intrusion, expectation, and relational strain. The Daily Mail's defense team, for its part, remained a constant counterbalance. Their emphasis on responsible journalism and legitimate sources was more than legal posturing. It was a methodical, disciplined reinforcement of public perception. By framing the stories as rooted in proper sourcing and devoid of unlawful activity, they sought to neutralize both the legal claims and the emotional resonance of Harry's testimony. Yet, even their strategy revealed the paradox at the heart of the trial. The press that had allegedly violated Harry's privacy was now participating in the courtroom drama as both subject and interpreter, amplifying the tension between law, personal experience, and public opinion. Adding another layer of complexity were the small but significant interactions that went unnoticed by the general public. Subtle glances exchanged between Harry and his legal team, the almost imperceptible reactions to cross-examination, the careful management of timing and pacing. All of these became part of a narrative that was simultaneously legal and deeply personal. In essence, the courtroom had become a theater of human behavior, a space where emotion and strategy intersected with striking clarity. Observers noted that this intersection extended to family dynamics. Princess Anne's indirect presence continued to shape decisions. Moments of pause, careful phrasing, and calculated restraint were attributed in part to her influence. Though absent in person, her guidance, always measured, principled, and uncompromising, served as both compass and constraint. Catherine's indirect role, though subtler, was equally impactful. Long-standing tensions, historical interactions, and the optics of perception created a web of influence that Harry navigated while presenting his case. And Meghan's residual impact, present through the lens of personal history and emotional shaping, added yet another layer of nuance to his demeanor and testimony. By the second week of testimony, the courtroom rhythm began to reveal its cumulative effect. Each day built upon the last, layering procedural detail over emotional resonance. Patterns emerged, the interplay of law and human behavior, the tension between personal narrative and public perception, and the challenge of asserting agency in a space where every move was scrutinized and amplified. Harry's strategy, both conscious and intuitive, reflected a sophisticated understanding of these dynamics. He managed to assert his claims while preserving dignity, to reveal vulnerability while maintaining composure, and to navigate relational tension without derailing legal focus. And yet, the trial's pressure was not solely external. Internal reflection, private anxiety, and the haunting awareness of long-term surveillance compounded the experience. Harry had spent a lifetime balancing public expectation and private desire, and now he faced a scenario where both collided. The courtroom was not just a legal venue. It was a crucible, testing endurance, judgment, and emotional calibration under conditions that few outside his immediate circle could comprehend. As questions grew more pointed, the intersection of past intrusion and present testimony sharpened. Specific instances of alleged unlawful information gathering were dissected. The defense challenged memory, interpretation, and intent, while Harry sought to assert clarity, credibility, and the fundamental principle of privacy. Each exchange was a microcosm of the broader narrative, a struggle between individual rights and institutional power, between lived experience and procedural interpretation, between history and immediacy. And then came the moments that revealed the psychological toll most starkly. Pauses before responses grew slightly longer, inflections subtly altered under pressure, micro-expressions betrayed suppressed emotion. Observers attuned to human behavior could sense the strain, the conscious management of self, and the interplay of memory and emotion in high-stakes testimony. These were the moments that no transcript could fully capture, the moments that conveyed truth beyond words, truth shaped by lived experience, context, and long-term scrutiny. The trial, though meticulously planned, was evolving organically into something far more revealing. Each day added texture, contradiction, and tension. The courtroom became a lens through which both law and humanity were examined, and through which public perception was continuously reshaped. And even as the evidence was laid out with precision, the human story, the pressure, the influence, the emotional resonance, was equally central, demanding attention, analysis, and interpretation. What happened next would force Harry to confront not only the legal challenges before him, but the cumulative impact of a life lived under relentless observation, a confrontation that would reveal cracks, tensions, and revelations that no one outside the courtroom could yet foresee. As the trial edged deeper into its second week, the courtroom's atmosphere shifted subtly but unmistakably. The initial procedural rhythm, opening statements, timelines, and document review, had given way to moments of personal revelation. Harry's testimony began to traverse not just legal claims, but the intricate web of private tensions that had shadowed him for years. It was no longer enough to recount events or cite sources. He was being asked to convey lived experience, to navigate the delicate balance between legality and emotion, and to maintain composure under scrutiny that few could endure. The unseen hand of Princess and continued to influence every step, quietly shaping strategy and reminding Harry of the stakes. Her guidance, though indirect, hovered in the margins of every decision. How to phrase responses, when to pause, when to assert. Insiders describe her approach as precise and unwavering, a reminder that even within the private walls of family council, one is never entirely free from expectation. For Harry, this meant constantly negotiating between internalized advice, legal strategy, and his own instinctual reactions. Every word, every gesture, was both a statement and a negotiation. Catherine's influence was present in a different, more subtle way. Observers note that prior public and private interactions had created undercurrents of tension, the kind that rarely erupted into overt conflict but shaped perception, behavior, and response. It was a quiet, almost invisible influence, yet its effects were evident in moments of hesitation, phrasing, and even body language. Every recollection, every account Harry offered, carried an undercurrent of relational awareness. He was defending privacy while indirectly acknowledging intricate interpersonal dynamics. How do you maintain clarity when the past intertwines with present obligation and the observer interprets every nuance as motive? And then there was Meghan, whose absence was paradoxically felt everywhere. Years of shared pressure, media scrutiny, and personal negotiation had left a mark, shaping both temperament and strategy. Those close to Harry suggest that her influence, supportive at times, complicating at others, manifested in courtroom demeanor, precise phrasing, carefully measured emotion, and the subtle modulation of intensity. Even when testimony remained procedural, the traces of personal history were palpable, informing choice of words, tone, and emphasis. Could the law ever fully account for the human dimension of lived experience? Or is the courtroom destined to interpret emotion only through the lens of legality? The interplay of media pressure with personal tension became increasingly evident. Each day of testimony produced microcosms of influence and scrutiny. A brief pause before naming a source, a glance at counsel, the measured delivery of emotionally charged passages. The press outside, of course, amplified every observable nuance. Headlines splintered reality into digestible soundbites. Harry either controlled the narrative or faltered under pressure, depending on which outlet one followed. Social media compounded the effect, reinterpreting gestures, and phrasing in real time. For Harry, the challenge was not simply legal. It was existential, negotiating authenticity under relentless observation while defending deeply personal boundaries. As questioning advanced, subtle contradictions emerged. Harry's memory, shaped by decades of intrusion, occasionally conflicted with defense claims. These moments were minor in the grand scheme of law, yet profoundly human. A pause before clarification, a subtle hesitance, a word carefully chosen after an internal calculation of potential implications. Each micro-decision conveyed the underlying tension between truth, strategy, and vulnerability. Observers trained to notice behavioral cues could see that the strain of prolonged scrutiny was beginning to surface, not as a weakness, but as a testament to the complexity of balancing legality with lived experience. It was also evident that Harry's team had anticipated these dynamics. Lawyers guided testimony with precision, anticipating lines of questioning designed to probe both fact and credibility. Yet, even in this highly structured environment, there was room for human unpredictability. Harry's emotional investment in the case, the decades of perceived intrusion, and the underlying family tensions made certain moments inherently volatile. Each exchange became a layered negotiation, factual clarity, emotional resonance, and public perception intersecting in real time. This week also revealed the subtle, invisible influence of preparation and rehearsal. Friends and insiders described the meticulous attention paid to phrasing, tone, and sequencing of testimony. But preparation, no matter how extensive, cannot fully shield one from the emotional undercurrent of recounting deeply personal experiences. Moments of vulnerability surfaced. The hesitation before recalling specific incidents, the careful delineation between public and private, the almost imperceptible shift when discussing family dynamics. These nuances, though subtle, offered insight into the human cost of long-term scrutiny and the extraordinary effort required to maintain control in a highly charged environment. The courtroom itself, with its imposing architecture and formal layout, contributed to the psychological landscape. High ceilings, echoing footsteps, and the regimented arrangement of participants reinforced hierarchy and authority. Harry, acutely aware of these factors, navigated the space with careful attention, posture, pacing, and eye contact, all calculated to convey poise while containing emotional intensity. In this controlled theater, the boundaries between personal narrative and legal argument blurred, making the human element inseparable from procedural proceedings. Outside the courtroom, media coverage amplified these dynamics. Analysis ranged from admiration of Harry's composure to skepticism about motives, with each outlet emphasizing different facets of the testimony. Social media users speculated, debated, and projected interpretation onto partial glimpses of the proceedings. The trial had become not only a legal event but a public narrative in continuous formation, shaped as much by observation as by evidence. And for Harry, this dual stage, the courtroom and the court of public opinion, created unique pressure. How to assert truth while managing perception, emotional resonance while navigating strategic constraint. By midweek, the cumulative effect of these intersecting pressures was increasingly visible. Moments of hesitation, micro-expressions, and subtle shifts in tone conveyed not just legal argument, but the psychological weight of decades-long intrusion and familial expectation. Harry's testimony, while precise and disciplined, revealed the complex interplay of personal experience, relational dynamics, and strategic calculation. Each detail, each pause, each carefully chosen phrase became a marker of resilience and of the persistent challenge of navigating a life scrutinized from every angle. And yet, even as this week concluded, an undercurrent of unresolved tension remained. The private, hidden pressures, the whispered guidance, the internalized warnings, the unspoken expectations, all shaping testimony in ways the public could only infer. The courtroom revealed fragments of a larger story, but the full scope of personal strain and relational complexity remained largely invisible, leaving observers to wonder what might surface next and how far the emotional undertow might push a man under extraordinary pressure. The next revelation would not come in documents or procedural argument. It would come in the form of confrontation, subtle yet piercing, a moment that threatened to expose the deepest intersection of past grievances, media scrutiny, and family influence. And no one outside the courtroom could fully predict how it would unfold. As the trial moved into its third week, the courtroom's energy shifted again, heavier now, more charged. Harry's testimony had already laid a foundation of personal experience and procedural assertion, but the real tension began when past interactions collided with present scrutiny. This was not simply about newspapers or legal precedent. It was about decades of human history, memory, and unresolved grievance now made public, each thread tugging at the delicate fabric of reputation and perception. It began subtly, almost imperceptibly. A question about a publication 20 years ago triggered a hesitation that lasted just a fraction of a second, but in that brief moment, the courtroom seemed to contract. Observers note that it was the kind of pause that reveals both the mind working and the emotion simmering beneath the surface. Here was a man reliving intrusion, not an abstract, but with intimate recall, and even rehearsed composure could not completely mask the human response. How do you convey decades of personal violation while remaining within the boundaries of law? It's a question that only someone living this experience could fully understand, yet the echoes of it were visible to all who watched. Then came the first overt confrontation, quiet but potent. A line of questioning, designed to test memory and credibility, forced Harry to navigate a fine line between assertion and overexposure. Each response had consequences. Legally, emotionally, and in terms of public perception. The Daily Mail's defense team pressed for precision, for acknowledgement of discrepancies, for contextualization. But the pressure was double-edged. Each factual correction, each clarification, risked amplifying the narrative that Harry had delayed action or overreacted. It was a paradox. Honesty demanded both vulnerability and precision, and any misstep could be misinterpreted in the very arena he sought to reclaim control. In these moments, the influence of Princess Anne was indirectly palpable. Though not present, her guidance was embedded in Harry's strategic choices. Sources suggest that she had emphasized caution, accuracy, and composure, particularly in exchanges that could expose relational tension or emotional volatility. The wisdom of such guidance was evident in Harry's responses, which managed to convey personal experience without overtly collapsing into emotional frustration. Yet, even with this influence, the tension was unmistakable. Each carefully chosen word carried the weight of expectation, both legal and familial. Catherine's presence, once again, was more spectral than visible. Past frictions, long-standing and subtle, seemed to inform certain word choices, phrasing, and tone. A glance, a remembered comment, a gesture observed years earlier. All filtered into how Harry navigated questioning about shared royal responsibilities, public perception, and interpersonal dynamics. The courtroom, in this sense, became a crucible not just for legal argument, but for relational history. It was a place where past grievances could be replayed in the form of testimony, reframed, and scrutinized for both credibility and emotional resonance. Meghan's indirect influence continued to emerge, shaping both demeanor and strategic approach. Friends and insiders described the residual impact of years of partnership under intense public scrutiny, a heightened sensitivity to tone, a cautious management of emotional expression, and a deliberate framing of incidents that preserved privacy while asserting agency. Even when questions were procedural, the emotional subtext was unmistakable. The trial had become a space where long-term private dynamics intersected with legal formalities, producing moments of subtle but profound tension. Observers noted that,